Supreme Court has said that marriages don't require public declaration. This decision has come in context of a case that was filed by a person whose wife was taken away forcibly by her parents. So in Tamil Nadu, there is a special section, Section 7A, that was added through a state amendment in 1967 in the Hindu Marriage Act 1955. Under this Section 7A of Hindu Marriage Act 1955, self-respect marriages have been given legality. These self-respect marriages follow no rituals. There are no rituals, and marriages are solemnized in the presence of relatives, friends, or other persons. The state law says that the parties to the marriage can proclaim in whatever language they understand that one person accepts the other to be his or her wife or husband, and the parties can also garland each other, place rings on each other's fingers, or tie the thali to solemnize the union as per the law, and this marriage is legal or valid. So this was self-respect marriage. It was done to do away with all those rituals, traditions generally related to the upper caste in Tamil Nadu. But in 2014, Madras High Court gave a judgment in which it disapproved of marriages that were being conducted by advocates in their offices under Section 7A of Hindu Marriage Act. So citing this 2014 judgment, the same High Court again disapproved the marriage of the person who got married in advocate's office, but they were forcibly separated. The wife was taken away by the parents, so he filed a habeas corpus petition in Madras High Court. But Madras High Court set aside his marriage and said that this marriage is not valid based on that 2014 judgment, and said that advocates cannot perform these marriages because in 2014 judgment the court had said that marriages performed by advocates in their office is not valid unless it is registered under the Tamil Nadu Registration of Marriages Act 2009, and it also required the physical appearance of the parties to the marriage before the marriage registrar. So after rejection of his petition in Madras High Court, this person went to Supreme Court. Now Supreme Court has given its decision. It has set aside the Madras High Court's ruling and overturned the 2014 judgment also. It declared that couples who are intending to marry may refrain from making a public declaration due to various reasons. There may be familial opposition or fear for their safety. So in such cases, enforcing a public declaration could put lives at risk and potentially result in forced separation. Supreme Court also said that the 2014 judgment of Madras High Court takes a narrow view of individuals' fundamental right under Article 21. It also quoted number of its judgment where it recognizes right to choose a life partner under Article 21. Supreme Court clarified that there is no blanket ban on advocates solemnizing self-respect marriages under Section 7A of the Hindu Marriage Act, and it said that self-respect marriages can indeed be solemnized and recognized. However, at that time, advocates should not be acting in the capacity of legal advisor, advocate, or as an officer of the court. Advocates have many roles and they can perform these marriages in personal capacity when they are acting as a relative, friend, or social activist. They can volunteer to solemnize these marriages. So there cannot be blanket ban on advocates solemnizing these marriages. In 2001 also, the Supreme Court had already recognized the validity of self-respect marriages under Section 7A of the Hindu Marriage Act, and it said that presence of priest is not obligatory for a valid marriage, and parties can enter into marriage with the participation of relatives, friends, or other individuals. By setting aside these judgments of Madras High Court, Supreme Court accepted the habeas corpus petition. The girl was called and her testimony was taken where she declared that she wanted to live with the man she married. So this was all about Supreme Court ruling on self-respect marriage. Thanks for watching.